Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 31 in the series Indian Polity. And as I already stated, the objective of this series is to provide a comprehensive idea on the subject Indian Polity. But in the process, I will also cover the important books, especially the book LAXMIKANTH will be covered. So many students do message me and keep asking that, sir, can you do a separate series on LAXMIKANTH? So this series is nothing but it is of course a series in LAXMIKANTH, which is similar to that of my previous series. But in addition to that, I'll also cover certain things which might be relevant to the students from the mains point of view also. That's only an addition to what you have already seen, but otherwise it is nothing going to be less than what my previous series is. Alright, so with that we'll just enter into the next lecture, that is where we are looking into Article 21 of the Constitution. In the last lecture, if you see, I was trying to make you understand as to what is the right to life or personal liberty and to what extent it is guaranteed in the Indian Constitution. And if you have gone through my previous lecture, I would recommend all the students watching this lecture to go through my previous lecture before you come to this particular lecture, at least my previous lecture, if you want to understand the concept of what is called as procedure established by law versus due process of law. And that's very, very important for you to understand as to what is this procedure established by law and how is it different from the concept of due process of law. But before I go explaining as to what is procedure established by law and due process of law, let me also take a brief summary of what you have seen in the previous class, especially with regard to Article 21 of the Constitution. Now, what is the Constitution is saying? Constitution is saying no person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. That means it has to be very clear in our mind that right to life or personal liberty is not an absolute right. It can be restricted. And how it can be restricted? It can be restricted only in accordance with the procedure established by law. That's the meaning you should have. So when I say no person, this right is not only available to the citizens but also to any aliens. So either a citizen or an alien. So nobody shall be deprived of their right to life or personal liberty. And what does it mean by right to life? Right to life means it is not merely an physical existence, right to physical existence or a life similar to that of an animal life, but it is a life which is a meaningful life, which is a dignified life. That's the interpretation that is given by the courts. And right to liberty means, personal liberty means it is not just somebody is restrained physically, arbitrarily, physically restrained or they are arrested, but right to liberty would mean as a free man, out of his free will, he should be able to do a number of things that will of course make him happy. That's basically what is called as right to liberty. Now, giving this interpretation, the courts have already said there are a lot of rights that is implied under Article 21 of the Constitution. We have also seen some of them in the last class, like right to environment, right to clean environment, right to privacy, right to marry a person of one's choice. So these are all some of the rights which the Supreme Court has said that is implied under Article 21 of the Constitution, which also includes right to die with dignity, which we'll subsequently see, which is also called as euthanasia in our country. We'll touch upon all those things, the application of Article 21 as we'll proceed further. But today, for time being, what you'll have to understand is what is the difference between procedure established by law versus due process of law. So while Article 21 is saying that no person shall be deprived of his right to life or personal liberty except in accordance with the procedure established by law. So we'll have to understand as to what is this procedure established by law. And in the last class, I already told that though the Constitution reads even today that the right to life and liberty shall not be deprived except in accordance with the procedure established by law, the Supreme Court in the Maneka Gandhi case has categorically said that the term procedure established by law will have the same meaning as that of what is called as due process of law. So we'll have to exactly understand as to what is the difference between them. And in the process, we'll also understand as to what is this Maneka Gandhi case and also what is this A.K. Gopalan case. Because A.K. Gopalan case is a case where the Supreme Court reiterated on the concept of what is called as procedure established by law. But whereas this doctrine was modified by the Supreme Court in a case which is called as the Maneka Gandhi case in 1978. We'll also try to understand under what background, under what backdrop all these things have happened. So we'll try to understand these things. So first let me explain you as to what is this A.K. Gopalan case and what is this Maneka Gandhi case, and then subsequently I'll come into what is called as the procedure established by law versus what is called as due process of law. And therefore you'll have a broader understanding of what this article is all about. And right now, if at all the right to life and liberty is to be deprived, how it can be deprived. So that is basically what we are trying to understand. So first let me make you understand as to what is this A.K. Gopalan case, because these cases have led to the concept to change from what is called as procedure established by law to what is called as due process of law. Now A.K. Gopalan case happened in the year 1951. A.K. Gopalan is a communist leader and he was from the state of Madras. So it happened in 1951. A.K. Gopalan was arrested by the state of Madras. And A.K. Gopalan was arrested by the state of Madras under a law which is called as the Preventive Detention Act. So at that point of time, there was a law which is called as Preventive Detention Act 1950. So Preventive Detention Act, in fact 1951. So based on this particular act, he was arrested. And when A.K. Gopalan was arrested, he challenged his detention as per this particular act, that this detention is illegal. And why he challenged his detention is illegal? Because to him it is violative of number of fundamental rights. So basically A.K. Gopalan was detained by the state of Madras for certain reasons, but it was legally allowed under the Preventive Detention Act. So as per the Preventive Detention Act, A.K. Gopalan was taken into detention. And in fact, A.K. Gopalan was taken into what is called as preventive detention, because his law allows for what is called as preventive detention. So for which, first you'll have to understand as to what is preventive detention. Now what do you understand by preventive detention, which we'll see elaborately when I take up Article 22 of the Constitution, which talks about two types of detention, in fact punitive detention as well as preventive detention. For the time being, I'm not going in depth into it. For time being, let us have an understanding what is preventive detention. Preventive detention is a detention without a trial. That means the individual has not gone for any trial because he has not committed any offense in the first place. So preventive detention is basically a detention which is preventive in nature, which is proactive in nature. So because otherwise if an individual is not detained by the state authorities, the state is having some suspicion that the individual might do something that might affect the interest of the state or that might affect the public interest. For this particular reason, even before an individual is committing some offense, he is already taken into detention by the police. So he has not committed any offense. And even before he is committing something, based on maybe the intelligence input of the state is acting in a preventive manner, or I would say a proactive manner, taking an individual into detention. That's basically what is called as preventive detention. And there was a law which is called as a Preventive Detention Act that allowed the state to take someone into preventive detention. So the state of Madras at that point of time was Congress government, and A.K. Gopalan was from Communist Party. So as per the various texts, that A.K. Gopalan was planning for some protest against the state of Madras. So basically the government, and therefore he was taken into detention. So then subsequently A.K. Gopalan has challenged this detention on the ground that his detention is basically violative of number of rights. In fact, he said that his detention is violative of Article 19, his detention is violative of Article 21 and also Article 22 of the Constitution. So this is how he challenged it. His detention is violative of many of the fundamental rights. Therefore, he should be given a remedy because this detention is violating number of fundamental rights. And then the court was to apply the principle of what is called as procedure established by law, because the Constitution is saying no person shall be deprived of the right to life and liberty except in accordance with what is called as procedure established by law. So in the process, we will also try to understand as to what is procedure established by law. So now let us just pass it here. Now let us go to the concept of what is called as procedure established by law. And even before I go to procedure established by law, you will have to also understand one thing. One argument that was made in the A.K. Gopalan case, when he was telling that his detention is illegal in nature, his detention is invalid in nature, he also tried to make an argument in a court of law that saying that the fundamental rights are not watertight compartments. In fact, the fundamental rights are related to one another. Never ever before the Supreme Court has agreed to this particular idea, or that this idea was taken into consideration that the fundamental rights are related to one another, which means that if one fundamental right is violated, possibly it could violate the other fundamental right also. So A.K. Gopalan was saying that fundamental rights should not be seen as an independent compartments or watertight compartments, but rather they are related to one another. In fact, he said that if my right to life and liberty is violated, that is, if I am illegally detained, probably it may also violate my right to freedom of movement, probably it may also violate my right to freedom of speech and expression. Therefore, it could also be violative of my right to freedom under Article 19 of the Constitution. So this was the connection he was trying to make, but the Supreme Court was not convinced. The Supreme Court is of the opinion that the rights are independent in one another and there is no connection between these rights, and as long as whenever your right is violated or whenever your right is taken away, if it is taken in accordance with the law, if it is taken restricted in accordance with the Constitution, then there is no remedy. So they were not willing to accept to the idea of what is called as the rights are interconnected. So with that, let us just try to go back and let us try to understand as to what is this procedure established by law, because basically when A.K. Gopalan was challenging his detention in a court of law, then the Supreme Court has to take, because majorly he was challenging it on the ground of what is called as Article 21, because when he said that it is also related to the other rights, say for example that is Article 2019 and Article 22, the court was not willing to accept this. The court said there is no relation to Article 19 because basically what is affected here is your right to life and liberty. So we'll see whether your right to life and liberty is deprived in accordance with the procedure established by law. Because even your right to life and liberty is not an absolute right. It can be deprived. How it can be deprived? It can be deprived in accordance with what is called as procedure established by law. So we'll apply that particular test and we'll see whether it is violated in accordance with the procedure established by law or not. So there is no way that it is related to violation of your right under Article 19. So we will not accept that. And in relation to Article 20, he was saying that it is also violative of his right under Article 22 because Article 22 also provides certain protection in case of detention. But the court was convinced that your detention is not punitive detention, because in case of punitive detention there is a need for a trial and all those things. But whereas your detention is preventive detention, and there is a law which allows for a preventive detention. So we also don't see that your right under Article 22 is violated. So the only question that can be there is whether your right under Article 21 is violated or not, that is your right to life and liberty. And to that extent we'll apply the doctrine of procedure established by law and we'll see whether your right is violated or not. So the Supreme Court applied the doctrine of procedure established by law to see whether A.K. Gopalan right has been violated or not under Article 21. So to see whether the right to life and liberty is deprived in accordance with procedure established by law, we'll have to understand what is to be tested by the judiciary in accordance with procedure established by law. So basically, how do you understand or what do you understand between procedure established by law and due process of law is that basically if any individual approaches the court, and what is the ground on which he approaches the court? He approaches the court saying that my right to life and liberty has been deprived. So under such a circumstances, the judiciary will check whether the right to life and liberty has been deprived or not in accordance with procedure established by law and due process of law. Suppose let us assume. That means basically there are two types of test. So these types, the two types of tests are little different from one another. So before 1978, that is before the Maneka Gandhi case, if somebody goes to the court and if they say that their right to life and liberty has been deprived, the Supreme Court was applying the test of what is called as procedure established by law. And if as per the procedure established by law, if the right to life and liberty is deprived, then there is no remedy to the individual. But if the right to life and liberty is deprived, after 1978, somebody goes to the court, they say that my right to life and liberty has been deprived, then the court is going to apply the doctrine of what is called as due process of law. And if it is deprived only in accordance with the due process of law, then only the deprivation of right is valid. Otherwise, it is illegal. Otherwise, it is in violation of the fundamental rights. That means to that extent, what is the difference between procedure established by law and due process of law? So you can understand the timeline when A.K. Gopalan has gone to the court, it was in 1951. So at that point of time, the court has applied the doctrine of what is called as due process of law. Sorry, at that point of time, the court has applied the doctrine of what is called as procedure established by law. So by applying the doctrine of procedure established by law, it has made the following test. So this is basically what you'll have to understand. So prior to 1978, it was procedure established by law. After 1978, it was due process of law. So before 1978, when they are applying the doctrine of procedure established by law, what are the tests that the judiciary has applied? So this is what you'll have to understand. So when somebody goes to the court will apply whether the law has been enacted following the due procedure. So first it has to see the enactment of that particular law. So what does it mean by enactment? So enactment means how the law has been made, whether the law has been made by competent authority. That is basically what is called as enactment. Because you know that there are competent authorities to make laws. So for example, Parliament is a competent authority to make law in certain areas. The state legislature is a competent authority in making laws in certain areas. So first thing that probably the court has to see is whether the law has been enacted by a competent authority, whether they have followed the proper procedure in enacting that particular law. Okay, yes, there is a law that has been made by a competent authority. So the first thing is whether there is a law and that law has been enacted by a competent authority. Yes, the enactment is correct. And now the next thing that will say is whether the law lays down certain procedure. What is the procedure that is there in the law? Whether the law lays down certain procedure. So what does it mean by when I say that whether the law lays down certain procedure? That means, say, let us assume there are a lot of criminal laws today in our country which lays down certain procedure as to what the police has to follow. Say for example, even if somebody has made a mistake and the individual has to be arrested in accordance with the law, it cannot be done arbitrarily. Say for example, if it is a non-cognizable offense. For a non-cognizable offense, the criminal laws, the procedural law says that an individual cannot be arrested by the police without an arrest warrant issued by the court. That's a procedure that is laid down in the law. So first of all, you'll have to see whether a law is there or not, and that law has been enacted by a competent authority or not. So first enactment and a law, and then whether the law is laying down certain procedure, and if the law is laying down certain procedure, whether the procedure has been followed. That is the last thing. Whether the procedure has been followed as it is laid down in the law, whether the procedure is followed. So these are the three tests probably that the court will apply in order to see what is called as procedure established by law. Let me just repeat it again. So what does it mean by procedure established by law? First thing that the court will see, if anybody is challenging that the right to life and liberty has been deprived, the court will see whether there is a law and whether that law has been enacted by a competent authority. That means whether the procedure based on which the law has been made is correct or not. So that is about the enactment of the law. Second thing, whether the law lays down certain procedure as to how the right to life and liberty is to be deprived. What is the steps that is to be followed? What is the step by step that is to be followed? Whether it is laid down in the law or not. So if the law lays down a step by step procedure as to how a right to life and liberty of an individual has to be deprived. Now the third step is whether these procedure has been followed properly by the implementing authority. So these three things will be seen. For example, a law allows for an individual to be arrested. That is the law. So the first thing that the court will see is whether there is a law, whether the law has been made by competent authority. Okay, the first condition is satisfied. The second condition is whether the law enforcement authority is following the procedure that is laid down in the law. First, second thing is whether there is a procedure. Yes, if there is a procedure. And the third thing is whether this procedure has been followed step by step or not. So if all the three things are there, then the court is convinced that this is a right way of depriving the right to life and liberty of an individual. If following this particular procedure somebody is arrested, the court will not see that as a violation of their right to life and liberty. Although arrest deprives an individual of their right to life and liberty, but the right to life and liberty of an individual is not an absolute right. It can be deprived in accordance with the procedure established by law. So to satisfy the condition of procedure established by law, first thing you'll have to see whether there is a law. Second thing, whether the law lays down a procedure. Third thing is whether the procedure laid down in the law has been followed by the competent authority or the law enforcement authority. If all the three things are satisfied, then the right to life and liberty of an individual can be deprived in accordance with what is called as procedure established by law. So now come to the A.K. Gopalan case. So A.K. Gopalan was basically arguing this right to life and liberty is to be has been deprived. So the court has seen, okay, we'll apply the test and we'll see whether your right to life and liberty has been deprived or not. So the court has seen whether there is a law. Yes, there is a law. Preventive Detention Act is there. So the first condition is satisfied. The law is there. So therefore, the first condition is satisfied. The law is nothing but the Preventive Detention Act. Second is whether the law lays down certain procedure. Yes, the law is laying down certain procedure as to how your right to life and liberty is to be deprived. So now the third thing is whether the procedure is followed. So we also see the law enforcement authority has followed the right procedure as it is laid down in the law. So this is also followed. So we do not see any violation of your right to life and liberty, because your right to life and liberty is not an absolute right, and hence your right to life and liberty can be deprived in accordance with the procedure established by law. So there is no remedy for you in this particular case, because your right to life and liberty has been deprived in accordance with the Constitution, that is in accordance with the principle of procedure established by law. But however, the court did not accept the argument when A.K. Gopalan made that it is not only about Article 21, but it is also about violation of the other rights, that is Article 19 and Article 22. But the court said no, the other rights are different. So as far as your right to life and liberty is concerned, we will apply only this particular principle, and hence your right to life and liberty is deprived, but it is accordance with the procedure established by law. So it is not violation of the Constitution. So this is what has been given by the Supreme Court in the A.K. Gopalan case, and thereby the Supreme Court has given its stamp of approval to the concept of what is called as the procedure established by law. And this concept of procedure established by law continued till 1978. Till 1978 this continued. In 1978, the Supreme Court has changed its previous stand that if at all the right to life and liberty of an individual is to be deprived, it has to be deprived only in accordance with what is called as the due process of law and not what is called as procedure established by law. Now, how this has happened, for which we will have to understand as to what is called as the Maneka Gandhi case. I will just discuss about the Maneka Gandhi case, but what is the problem in this particular doctrine? That is the procedure established by law. There is one big problem in this particular doctrine. The problem with this particular doctrine of procedure established by law, to see whether the right to life and liberty of an individual has been deprived or not, it is merely seeing whether there is a law, and it is also seeing whether the law lays down the procedure. And the third thing it is saying is whether the procedure has been followed by the law implementing authority. And if these three conditions are satisfied, then the court is convinced that yes, the right to life and liberty has been deprived in accordance with the Constitution, and hence therefore there is no violation of fundamental right. But the biggest problem of this particular doctrine is the court fails to see whether the law is a just law, whether the law is a fair law, or whether it is an unjust law. That is not the matter that the judiciary is concerned. The judiciary is concerned whether there is a law and whether the law provides for a procedure or not. But what can be possible is there is a possibility that there is an unjust law, because under the procedure established by law, the judiciary does not look into the subject matter of the law. It only sees whether there is a law. It does not look into the procedure of the law. It only sees whether the procedure is there or not. It only sees whether the procedure has been followed or not. But it does not look into the subject matter of the law. It does not look into the procedure laid down in the law, whether they are just, fair and reasonable, or they are unjust, they are unfair and unreasonable. So these are not the questions that the judiciary will see, and that is why the Supreme Court has to review its own judgment and change its own stance, wherein they held that henceforth if the right to life and liberty is to be deprived, it can be deprived only in accordance with what is called as the due process of law, which they came out in what is called as a Maneka Gandhi case. Okay, before getting into that, let me just give an example. Say for example, there was an act which is called as Rowlatt Act. The Britishers have passed. I am sure that most of you might know of this Rowlatt Act. And this act was passed by the Britishers, and there was a lot of criticism to this Rowlatt Act. And what was a major provision of this particular Rowlatt Act? The Rowlatt Act, which was passed by the Britishers, allowed for imprisoning people, or allowed for conviction, or allowed for the punishing people even without a trial. There is no need for trial, and even without a trial people can be imprisoned. People can be convicted. So that was the provision of the Rowlatt Act. Now there is no such law right now in our democratic country. Right now in independent India we do not have such a law. But however, let us assume if there is a law like that, and if you have to apply the doctrine of procedure established by law, the procedure established by law will only see whether there is a law. Yes, Rowlatt Act is there. Whether the law provides for a procedure. Yes, there is a procedure. Whether trial or no trial, some procedure will be there, and whether the law enforcing authority has followed the procedure or not. and they will follow the procedure. So it may allow, if you don't apply the principle of what is called as due process of law, and if you just follow the principle of what is called as the procedure established by law, the biggest problem of this particular doctrine is that the justness, fairness, and the reasonableness of the law is not taken into account. That means the law can be bad, the procedure can be bad, and the procedure still may be followed as it is laid down in the law, and thereby you can deprive the right to life and liberty of an individual. It can be an unjust, unfair law, unjust, unfair procedure, but merely following that procedure and thereby depriving the right to life and liberty of an individual would become valid under the concept of what is called as procedure established by law. And that is the reason as to why the Supreme Court has to change its stance, and probably they have to come out with a new doctrine as in the American Constitution, where they follow the doctrine of what is called as due process of law to deprive the right to life and liberty of an individual henceforth from the Maneka Gandhi case in 1978. So let us quickly try to understand as to what happened in the Maneka Gandhi case, and then I'll just come back and we'll try to understand how it is different from the concept of what is called as due process of law. So what happened in the Maneka Gandhi case? Maneka Gandhi was asked to surrender her passport. She is the daughter-in-law of our former Prime Minister Indira Gandhi. So she was asked to surrender her passport, and there is a act which is called as the Indian Passport Act. As per the Indian Passport Act, the government can ask any citizen to surrender their passport. That the government is allowed to do. The law allows for it. So the government of India asked Maneka Gandhi to surrender her passport, and if you look into a lot of text, it appears there are a lot of political reasons behind all those things, but I am not getting into all those areas. Now the government asked her to surrender the passport, and she has surrendered the passport. And after she has surrendered the passport, then she asked the reason as to why the government is asking me to surrender the passport, because on behalf of the government, this power was exercised by a regional passport officer who is a competent authority under the Indian Passport Act. So the regional passport officer sent a notice to Maneka Gandhi asking Maneka Gandhi to surrender her passport, and as per the directions of the government, Maneka Gandhi has surrendered her passport. But after she surrendered the passport, she also asked the reason as to why the government has asked me to surrender my passport. But the government did not give any reason. They said that in public interest, we are not disclosing the reason. And such a provision is there in the Indian Passport Act. As per the law, the government is saying that in public interest, we are not disclosing the reason as to why you have to surrender your passport. The government is not wrong, because the law allows the government to not to disclose the reason as per the Passport Act. Then subsequently, Maneka Gandhi has filed a petition in the Supreme Court that this provision, that is the Indian Passport Act, under the provision under which my passport is seized by the government, or the government has asked me to surrender my passport, is completely violative of many of my fundamental rights. In fact, Maneka Gandhi said that this action of the government is violative of number of fundamental rights, including my Article 14, Article 19 and Article 21 of the Constitution. So this is the argument that she has made. She has not only said that it is violative of Article 21, she is saying that it is violative of many of her fundamental rights, including Article 14, 19 and Article 21. So this is what argument she has made. So she is again bringing it to the notice of the court that the fundamental rights are not watertight compartments, but the fundamental rights may be related to one another. That means violation of one right may lead to a violation of another right. So this is a classic example where she was trying to explain that. Say for example, she said that in the Indian Passport Act, as per the Indian Passport Act, the government has asked me to surrender my passport. That is all right. I have surrendered it, but I have asked for the reason, but the government has not given me the reason. That is the regional passport officer has not given me the reason, saying that we are not disclosing the reason in what is called as public interest. And to that extent, the law provides discretion to the passport officer. The law provides discretion to a government officer. So if the law provides discretion to a government officer, whether to give the reason or not to give the reason without giving me a fair opportunity to explain my case, because in this case, Maneka Gandhi was not given any opportunity to explain her case, and Maneka Gandhi was not given any reason as to why her passport was surrendered. Only when they will give the reason, Maneka Gandhi can make her representation. So if the government did not even tell her as to why her passport is seized or is to be surrendered in the first place, what is the reason or what is the counter argument that Maneka Gandhi can give? So she cannot absolutely do anything in this particular case. And in the words of Maneka Gandhi, as per his argument, that this is completely an arbitrary power or a discretionary power which is given in the hands of the regional passport officer and which can be misused. And if it can be misused and this discretion is given, that would be amount to violation of what is called as right to equality. Because this discretionary power can be differently exercised to different people by the regional passport officer at his own discretion. He may give reason to someone, he may not give reason to somebody else. If he does not like someone, he may not give the reason. If he likes someone, probably he may give the reason. So that amounts to the principle of equality under Article 14 of the Constitution. It's not only violative of Article 14 of the Constitution, but it is also violative of Article 19 of the Constitution. How it is violative of Article 19 of the Constitution? By depriving me of my passport. So her profession was, she was a journalist at that point of time, Maneka Gandhi. In fact, she made, it is not only violative of Article 14, by depriving me of my passport, you are also depriving me of my right to freedom of trade, profession and occupation, because I am a journalist, probably I'll have to travel abroad in order to carry out my profession. And by depriving my passport, you are also impacting my right under Article 19, Clause 1, Subclause G, that is right to freedom of my profession. And hence it is also violative of my Article 19 of the Constitution. It is also not only violative of Article 19, it is also violative of Article 21 of the Constitution by depriving me of my passport. By asking me to surrender my passport, you are also depriving me of my right to personal liberty, because it is part of my personal liberty to travel to a foreign country and to come back to India. So it is not only about personal liberty, is not only about not arresting an individual arbitrarily, but also depriving me from moving or depriving me from what I wanted to do is also deprivation of my personal liberty. And hence this action of the government through the passport officer is violative of my right under Article 14, Article 19 and Article 21 of the Constitution. Because this law, although it is there, and this law also gives the power to the passport officer to do so, but in my opinion, this law is unjust. And the procedure that is laid down in the law is unjust. It is unfair. Because this procedure is not allowing me to give it does not give me any opportunity to present my case. So without even knowing my case, without even giving me an opportunity to present my case, you are taking the action. That means it's an unjust procedure, unfair procedure that is part of this particular law. And hence, in the words of Maneka Gandhi, or in the Maneka Gandhi case, whenever the right to life and liberty of an individual is to be deprived, it should not only be seen whether there is a law, whether the law provides for a procedure, and that procedure has been followed or not. It should not only be seen, but what is to be seen most importantly, whether the law is a just law, whether the law is a fair law, whether the law is a reasonable law. Not necessarily whether a law is a just law, reasonable law or a fair law, but also whether the law provides for a just procedure as to how someone should be deprived of the right to life and liberty. Whether the other party is also given a reasonable opportunity to present their case. So the law should be just, the procedure laid down in the law should also be just and fair, and then it should also be implemented properly by the enforcement authority, and then only you can deprive the right to life and liberty of an individual. Otherwise you cannot deprive the right to life and liberty of an individual. And therefore the doctrine that has to be applied, a doctrine that is followed in United States of America, is what is called as the due process of law, which follows all these things. So therefore the doctrine that has to be applied in depriving the right to life and liberty of an individual is that you will have to apply what is called as the due process of law and not what is called as procedure established by law. So the basic difference between due process of law and procedure established by law: in procedure established by law, the court is going to only see whether there is a law and whether the law has been enacted properly, whether there is a law, whether the law lays down the procedure, and whether the procedure laid down in the law is followed or not. But the judiciary is not going to question the justness, fairness of that particular law. But whereas in the due process of law, the judiciary will not only see whether there is a law and the law lays down the procedure, but the judiciary should also see whether the law is a just law. What is the subject matter of that particular law? Is it just, fair and reasonable? Whether the procedure laid down in the law is just, fair and reasonable, and then it has been implemented properly by the law enforcing authority. And only when these things are satisfied, then only you can call that law to be what? Then only you can allow that law to deprive the right to life and liberty of an individual. So that's basically what is called as the difference between the procedure established by law and due process of law. Or in other words, the Supreme Court has made it very clear that under the doctrine of due process of law, if at all the right to life and liberty of an individual is to be deprived, if at all the right to life and liberty of an individual is to be deprived, so it has to satisfy all the conditions that you have seen under the procedure established by law. So what are the conditions that you have seen under the procedure established by law? It has to follow all the conditions that we have already seen, procedure established by law. In addition to those conditions that you have seen in procedure established by law, it should also see whether the law is just, fair and reasonable. Not just the law is just, fair and reasonable, but also the procedure that is laid down in the law is just, fair and reasonable. So the justness, fairness and reasonableness of the law and the procedure has to be followed, or it has to be seen by the courts. And then only we can say that it follows the principle of what is called as due process of law. So from Maneka Gandhi case, or after Maneka Gandhi case in 1978, the right to life and liberty of an individual can be deprived in accordance with what is called as the due process of law, which will basically check the justness, fairness and the reasonableness of the law and the procedure that is laid down in the law. That is basically you'll have to understand. Or in other words, to put it in a very simple way, to keep the entire discussion very short, while the procedure established by law will allow the judiciary to review only the executive action. That is, whether the procedure has been followed or not properly, nothing more than that. So for example, if the law allows for an arrest of an individual, it will only see whether the executive has followed the procedure that is laid down in the law, whether the police probably has followed the procedure laid down in the law. If the procedure is not followed by the police, then that would amount to violation of the right to life and liberty, because they have not followed the procedure that is laid down in the law. That is basically what is called as procedure established by law. So what can be questioned by the judiciary in accordance with the procedure established by law is only the executive action. So police here is nothing but an executive, but the judiciary is not questioning whether the procedure laid down in the law by the judiciary, whether the procedure laid down by the law by the legislature is fair or not. So they are not questioning the procedure itself, but they are only questioning whether the procedure as it is laid down in the law is followed or not. So in the procedure established by law, the judiciary will review only the executive action, whereas in the due process of law, the judiciary can review not only the executive action but also the legislative actions. That is, whether the procedure itself is fair in the first place, whether the procedure itself is just in the first place. And if the procedure itself is not just, and then there is no point in following an unjust procedure. So first the procedure has to be just in the first place, whether the procedure should be fair in the first place. Then that should also be applied properly by the law enforcement authority. So what can be questioned by the judiciary in accordance with the due process of law is that the judiciary will question both the legislative action and also the executive action. So that is basically what is called as due process of law. In fact, after the Maneka Gandhi case, the Supreme Court has made it very clear that if at all the right to life and liberty of an individual is to be deprived, it can be deprived in accordance with what is called as due process of law. And for due process of law to be satisfied, it has to satisfy the condition, any law which is allowing the deprivation of right to life and right to life and liberty of an individual, and that particular law should satisfy the condition of what is called as equality. That means it should not be in violation of Article 14. Not only the principle of equality but also reasonability, which means the lot of reasonable restrictions that is laid down under Article 19. So probably it should also satisfy the condition of reasonability. And apart from that, it should also satisfy the condition of what is called as the liberty, which is given under Article 21 of the Constitution. So all these conditions has to be satisfied to deprive the right to life and liberty of an individual. So that is basically what you'll have to understand. So to that extent, after the Maneka Gandhi case, it is not easy for the state to deprive the right to life and liberty of an individual, because they have to apply what is called as due process of law and not what is called as the procedure established by law. So this is basically what you'll have to understand. I'm sure that the difference between procedure established by law and due process of law is quite clear to all of you. So to put it in a very simple way, the procedure established by law does not look into the justness, fairness of the law, whereas the due process of law will also look into the justness, fairness of the law and the procedure that is laid down in the law. And that's basically what is called as due process of law. or to put it in one single word, the due process of law will always take into account the principle of what is called as natural justice. Whatever is the procedure that is laid down in the law, that has to follow, and it has to apply the principle of what is called as natural justice. And to that extent, what is the principle of natural justice? The principle of natural justice means any party who are affected because of a particular case, both the parties should be given a reasonable opportunity. Say for example, in the Maneka Gandhi case, one of the parties is the government, which is the regional passport officer on behalf of the government, and the other party is Maneka Gandhi. Well, the government is asking Maneka Gandhi to surrender the passport. So this is an action that the government is taking. So they should also let another party to explain as to why it should not be done, or at least they should give a reason so that the other party can make a representation. There's a misunderstanding from the side of the government to take this particular action. Unless and until you give another party to explain their case, then there is no principle of natural justice, because principle of natural justice would give equal opportunity to both the parties affected in a particular case or related to a particular case. And any procedure that would not follow the principle of natural justice, then in that particular case, that procedure is not a just procedure. That procedure is not a fair procedure. That procedure is an unreasonable procedure. And to that extent, the court can come to a conclusion that it is in violation of the principle of due process of law, and therefore that would also be violative of what is called as the right to life and personal liberty guaranteed under Article 21 of the Constitution. So this is basically what you'll have to understand. So I'm quite clear from our discussion. You are very clear as to what has happened in the A.K. Gopalan case and what has happened in the Maneka Gandhi case, and post 1978 how this doctrine of procedure established by law has been modified as what is called as due process of law under the Constitution of India. But however, keep this in your mind, even today the Constitution reads in Article 21 only as procedure established by law. But however, the Supreme Court has made it very clear that the term procedure established by law under Article 21 will have the same meaning as that of what is called as due process of law. So while it may read as procedure established by law, but in application, the doctrine or the principle that is used is only what is called as the due process of law. So this is basically what you'll have to understand. With that, I'll come to a conclusion of this particular discussion. Very, very important concept. If you have any queries or questions, you can reach out to me. But before we complete the discussion, just have a quick look into the question that is there. So try to solve this particular question, and if you know the answer, you can put it in the comment box. Consider the following statement. Statement 1. Protection in respect of conviction for offences is a fundamental right only to the citizens. Protection in respect of conviction for offences is a fundamental right only to the citizens. Is it a right only to the citizens? So you can just have a look into it. So we have already seen. So in the last lecture you have seen this, but anyways, if you know, you can try to answer this particular question. So statement number 2. The doctrine of procedure established by law allows the court to review the actions of both the legislature and the executive thing. So try to recollect as to what is the doctrine of procedure established by law allows the judiciary to review, and what is the doctrine of due process of law allows the judiciary to review. Which of the statements given above are incorrect? So probably you'll have to understand and select what is the incorrect answer here. So whatever is the answer, you can put it in the comment box. In case if you have any questions related to this particular lecture or in general related to the examination, you can reach out to me through my Instagram account or through my Telegram channel. And my Instagram account and my Telegram channel have the same, in fact, the ID, that is Babu underscore, BABU, Babu underscore IAS underscore 337. And before I wind up, I also like to request that in case if any of your friends or family members are preparing for this examination, you can refer these videos to them, and I'm quite sure it will be immensely beneficial to them in the preparation process. With that, I'll wind up the lecture today. So tomorrow I'll continue with some of the applications of Article 21. I said that the Supreme Court has said that a lot of rights implied under Article 21. So I'll discuss some of them in detail. So for example, right to privacy, the right to die with dignity, which is also called as euthanasia in India. We'll discuss some of those things for better understanding of how the Article 21 is applied to expand the rights that is given under Article 21. Okay, so thanks for watching this particular lecture. We'll meet again tomorrow. All the best.